Sorry, we made a change. Mr. McCoy was going to go first, but I'm just too antsy here. So
We know better.
Ms. Burke, it's your question that drove me out of my seat, because I really have to correct that. Because you're correct, and Mr. McGilvery is wrong. You talked about this example. I want to first say one thing. I do agree with Mr. McGilvery. He's correct on one thing. He is correct that these approvals are conditional. Planning board approval is conditioned upon the town council. The town council approval is conditioned upon it going back to the planning board, but not at any kind of remand from you. It goes back to the planning board for the next stage of review, which is preliminary plan. And this is exactly the same procedure when you have something that needs planning board and zoning board approval. It's a three-step process. And I'm going to take you way back because I was a member of the Wagon Commission, the Land Use Commission. And in 1991, I was on the group that wrote the Zoning Enabling Act. And that passed the General Assembly in 1991. And that didn't say anything about this precedence of approvals. And we realized in the intervening year while we were working on the next act, which was the Development Review Act, which was all the planning enabling statutes, which passed in 1992, there were actually two separate Superior Court decisions in Rhode Island. People had subdivisions. They had enough area, but they didn't have enough frontage. They're supposed to have 300 feet of frontage, 150 feet per lot. They had 275 feet of frontage. And they both ended up at the Superior Court. And one Superior Court judge, where it had gone to the zoning board first, said, no, that's wrong. The zoning board has no jurisdiction. The planning board has to do the subdivision first before it goes to zoning. And in the other case, it had gone to the planning board first, and the Superior Court judge said, no, that's wrong. The planning board doesn't have any authority to grant the subdivision when the zoning doesn't comply. So we realized there was a problem. And the Legislative Drafting Committee came up with, admittedly, a somewhat awkward process, but it was the best we came up with, and no one seemed to have improved on it in the 20-some years since, was 30-some years since, was to say there'll be this three-step process. If you need approval from both the zoning board and some other body, such as the town council or the planning board, you will go first to the planning board and get the first stage of relief from the planning board, conditioned upon the next step. And it also goes on to say, with the town council thing, also provide the recommendation at the same point. Then you go to the zoning board and you get the relief. And because they were concerned about zoning boards going off and changing and not following the planning board guidance, they said, you got to satisfy both. So you got to go back to the planning board for the third step of the approval. And that's what happens if someone's got something that's got a land development project and needs a special use permit from you. They do that, and it's the same process here. You go to the planning board, you go to the town council, go back to the planning board, but at the next step, preliminary. And that is how the law is set up, and that's how, as Mr. McGilvery, and I don't know if you even know if this latest one got to you, this thing yesterday, but he quotes the section from the general laws, and it says it shall first obtain an advisory recommendation on the zoning change from the planning board, as well as conditional planning board approval for the first approval stage of the proposed project, which may be simultaneous, and then obtain a conditional zone change from the council, and then return to the planning board for subsequent required approvals. And that's Rhode Island General Laws 45, 23, 61, B as in boy. And so that's the process, and it's one they're familiar with. It's a 30-year-old process. There's nothing new here. And that's what we're talking about here. Went to the planning board. The planning board made their recommendations. I'm going to talk about some of the specifics in a minute. But then, after the planning board, it went to the town council. The town council made their decision. If Mr. McGilvery's clients want to appeal that town council decision, they can do so. They can bring an appeal of that decision. They haven't yet. They still have time to do it. They may end up doing it. But that's a separate decision. It has nothing to do with the stay or anything like that. And as I said, the thing that I agree with Mr. McGilvery is it does need to go back to the planning board. But it does need to go back to the planning board at the next stage, preliminary plan approval. And that, by the way, is when all the other things like traffic reports and sewer capacity reports and drainage studies, all that stuff will happen at the preliminary permit. And it might not. It might not even, the planning board might not agree with the town council as to the density. The planning board may say, no, that's too many units, or it's not enough units, and it may get bounced back again, because that's the rule. You have to get approval of both the bodies when you have them. But it needs to go on to that next step. To short-circuit it at the first step is what Mr. McGilvery is trying to do in this case, which I don't think is appropriate. So let me just talk about a few specific things here, but I think that's the overall thing. They've spent a lot of time on the density and that density calculation in the zoning ordinance, that specific number 2,250 square feet. And they're saying, oh, the application for a zoning amendment was only afterwards. No, that's not the case. The applicant applied for a land development project from the planning board and a zone change at the same time on December 1st, 2021, an application that was dated November 30th. They applied at that point. They applied for something different. They wanted 151 units, I believe, at that time. They applied for that, but they applied for both. So that zoning, the application for the zone change was filed at that time. And Mr. McGilvery would have you believe that nobody knew while this went on for months that it was involving the zone change. But that's just ridiculous, because it was there at the beginning, first of all, for the planning board, and it's in your record, that November 30th dated application for a zone change was in the planning board packets when they had their first hearing in January of 2022.
It duly advertised.
It was not advertised for the town council. It was advertised for the planning board public hearing. Yes. And it was part of the discussions all along. And if you've looked at the records and the minutes and whatnot, there were lots of comments in the planning board. Well, it's going to be up to the town council in the end to decide what's the number of units, which is the density question. It's up to them. We're going to try to do it. And the planning board didn't even come to a consensus on it until the last minute. There was a vote to deny it unless the developer agreed to A, B, C, D, and E. And the developer did agree to A, B, C, and D, and compromised on E, and that was the number of units, and that came back. And the planning board did reopen the public hearing. After they had already voted and said, close the public hearing, and said, okay, 5-0, tell them it's denied unless they do all these things. When they came back with doing 4 out of the 5 things, they said, okay, well, we have to have a new public hearing because that's a change. So we reopened the public hearing.
And wasn't that in the, can I just interject, Mr. Teitz, wasn't that in the record of the minutes of the meeting on April 22nd?
April 14th.
April 14th, rather, Mr. McCoy?
Yes.
And I thought that the minutes reflect that the public hearing was reopened and there was discussion.
That's correct. So the public hearing was reopened, and everybody knew what they were talking about. This wasn't something that was pulled out of someone's pocket at the last minute and was evidence. And that really comes to the big question about this. I objected to Mr. McGilvery's, starting to give you a whole batch of exhibits, but the floor plan, he's making a big deal about the square footage. And the whole point is the whole thing is a red herring. Because that number, and this was discussed at several of the planning board meetings, in the public hearings. That number was backed into in 2008. The town council decided on 98 units in 2008. And that number was backed into to create that 2,250 square footage based on the 98. Everyone throughout from December 1st of 2021 through that April 14th public hearing knew that was on the table was they were asking for more units. Originally, they were asking for 151, and then they came down to 127. They were asking for that number, and that was, the density number was going to change based on whatever the number of units were. The number of units was going to be based on infrastructure capacity. Traffic, sewer, water, parking, things like that. That's what it was going to be based on, and the council would make the basis of that. So it really doesn't matter what that number was because it's irrelevant to the whole thing. In fact, the final version, the council was taking out the number entirely and putting in the zoning ordinance what they were doing anyway, which was saying, look at the infrastructure when deciding on how many units. Because this is a unique property. It might not have been quite as unique in 2008 before Stone Harbor was developed, but it is now. It's the only large mill on the water that isn't otherwise developed. It is unique. There's nothing else in Bristol that fits. You're familiar with density based on lot area per dwelling unit. That's kind of what our whole zoning code is based on, R6, R10, R20, R40. Well, how does that work when you have a building of, I don't know the number, let's just say anywhere, no matter who you believe, between 200 or 300,000 square feet, but only on a couple of acres of land. So doing it on lot area per dwelling unit doesn't make sense. The way you do it is what's appropriate to the infrastructure. That's what the council did, but in 2008, they also backed into the density. In 2022, it was being more straightforward and saying, we're basing it on the infrastructure, not any artificial density number of floor area, because that doesn't really apply either since this is a unique structure. We have to look at it.
Can I just interject?
Sure.
Are you suggesting in the language of that ordinance then does not apply to these unique circumstances? Is that what the planning board believed at the time during the
Yes,
hearing?
that's what I am suggesting. And it was discussed repeatedly at the public hearings. It's not some secret that came out. So basically, all of Mr. McGilvery's arguments as to that number of density, saying it's both clear error, prejudicial procedure error, and weight of the evidence, doesn't matter because it's not relevant to the decision at hand. It's basically a red herring because they found a mistake on the plans and they jumped on it. That's what it is. But it's not relevant, and it's not what the planning board decision was based on. It's not what the planning board decision had to be based on. And it's not what the town council decision was based on either, and they corrected that at that point too by removing that part from the ordinance. I want to just talk briefly about the affordable housing, because I think, again, there's been a bit of a twisting on this idea of grandfathered rights versus vested rights. Grandfathered rights, yeah, I mean, it is a term that everybody throws around. It's one thing to be an applicant, and if you're just applying for a permit and you get your permit for use, no, the town council can't change the zone on you before you can build what you got your permit for, or what your application is substantially complete. But we have an applicant here who's coming in and asking the town council to amend the zoning ordinance. It's not like the applicant came in and said, okay, we got this 2008 thing, we're going to go ahead and build 98 units. And the council suddenly started saying, no, wait a minute, only 78 units, and I'm going to change it. It was the other way around. They were applying to the town council to change that number and change other aspects of it as well, with less commercial space and different on the parking size, parking space width. So that, again, is kind of a red herring about what's vested or not. What's also interesting to note is the specific language of the 2008 zone change, which talked about, and the planning board, which talked about the density. In 2008, they basically said affordable housing between 10 and 20%, and some combination of on-site, off-site, and fee in lieu. That's what they said in 2008. And it's my position, and I think the planning board agreed as well, that until the town council changed that in July of 2022, that's what they still had the right to. It was this kind of wide open thing. And it was a very specific ordinance and text change, the specific controls over the general. The town put in, after 2008, the town put in inclusionary zoning, which required affordable housing. It wasn't even required before then on the ordinance. The town did allow a fee in lieu for a while. Then Rhode Island Housing changed the amount of fee in lieu that they would pay, and the town removed fee in lieu. All that stuff happened. At any time while any of that was happening, the applicant had a 2008 decision, which was specific to them, which said 10 to 20% and here and any part of the mix. So the town council, actually, the irony is the town council did in fact take heed of a lot of the concerns about affordable. And when it got to the town council, they said, no, the 15%, which the planning board said wasn't enough, it's got to be 20%. And we want to have at least we want to have at least 10 units in the mill complex itself and another 3 off-site, so that only half can be fee in lieu. So the town council didn't even...
Wait until the second.
Sorry.
Thank
So
you.
so the town council did it, but they didn't, that wasn't something that the applicant had, was coming and trying, that there was a change, that they were following the zoning ordinance, because it was a specific zone change that's for them. Even though the general ordinance had changed 3 times since 2010, that still didn't apply to their 2008 ordinance. So again, I just think it's a red herring. I don't think it's relevant. I don't see any error there anyway, but if there was, I don't see it as making any difference, because they were still governed by the 2008 ordinance.
Because it was a specific ordinance.
It was a specific ordinance. It was a map change for that particular file. Just as the 98 units was a map change for that.
As opposed to an ordinance of general application.
Yes.
Relative to affordable housing.
Yes.
That's good history, but the 2008 had to have expired, correct?
No. See, the 2008 land development project approval by the planning board did expire. Because those expire, they were actually extended all the way out to about 2018, because the General Assembly kept doing it. But a zoning amendment, where it's on the map, that doesn't expire. It's like any other zoning, it runs with the land. So the 2008 map amendment that the council did not expire.
Was in effect.
It was still in effect. That's why, let's say this applicant wanted to go ahead and build those 98, they wouldn't have to go to the council, but they'd still have to come back to the planning board for the land development project because it had expired. But the council one never expired, and it was still in effect until the day in July of this year that they changed it, or August that they changed it. I don't want to take too long here, I've probably already, but I just wanted to, one of the other things that Mr. McGilvery raises is the question about the application of the map change, and it didn't come in until May after the planning board voted. And again, I think I referred it. It was actually filed on December 1st of 2021. There was a revised application for the zoning change in May based on the decision of the planning board. Because, for example, the December one said 151 units. The planning board said 127 units. So they had to amend their application to the council to conform to what the planning board recommendation was. So it was an amended application, but it wasn't that it came in afterwards. And this thing that it should be referred back to the planning board, I forget, it might have been you, Mr. Burke again, that would just create a continual slingshot. Something would never get to the council if you followed that rule. The council, the issue about whether the council action should have been stayed, I think Mr. McGilvery is totally wrong, but I'm going to make it easy. It doesn't matter whether he was wrong or right, because even if the council hadn't acted before now, it still wouldn't change the question here of what's before you. You're looking at the question of a conditional master plan approval for the planning board and referral to the town council, and that's what you're looking at. And I would, even if we hadn't had town council action, I'd just be saying it's still for the council to decide. It doesn't matter whether they did decide or it's for them to decide. It was conditional with the planning board, so therefore it doesn't matter. As I said, I agree with, I think your counsel summed it up, that the language in the stay talks about from the furtherance of the decision from which it's appealed, so it stops any further planning board things, but it doesn't stop any other decisions. If we had to go to CRMC, the appeal from Ms. McGilvery would not have stopped us from going to CRMC in the meantime. If we had to go to DOT for a physical alteration permit, his appeal wouldn't stop it. It doesn't stop other things, it only stops the planning board process. So it really doesn't matter whether the council went forward or not, because you don't have to look at the council's ordinance to determine that there wasn't any judicial procedural error. There's no prejudice. They had more than enough of the public hearings, reopened public hearings. There's no clear error that applies. There's certainly far more than a scintilla of evidence to support the planning board's decision. So I think you can deny the appeal
Can you just,
on those basis.
for the board's benefit, can you just address the one issue about, what the one that Mr. McGilvery raised about the effect of the existing law and a subsequent appeal? And whether the decision is made under, whether it's conditional or otherwise, under a change in the law.
Well, I thought I just did. I think it doesn't really matter because it's conditional. Since the planning board decision was conditioned upon the town council, I don't think you even have to reach the question of, should you guys look at the town council decision? Actually, I think you should. They've acted and they weren't stayed, and it does add more weight to the evidence. But I don't think it matters for any of his arguments, because it was still a conditional planning board decision. And you've got to look at it and determine whether it was correct as a conditional planning board decision. It wasn't like the alternative I gave you. Let's say they were coming in and going for 98, and they didn't need any zone change or whatnot, and the planning board gave the master plan approval for 105, and yet the zoning said 98. Well, then you could look at it and you say, well, wait a minute, that's error. They can't do that. This is what the zoning is. But it was conditional, and it was conditional upon the council changing it. So that can't be a grounds for error, whether the council happens to have acted already or not. I'm happy to answer any other questions.
Mr. Teitz, the planning board understood what the process was going to be when they reviewed these, didn't they?
Absolutely.
So they knew that they were going to make a recommendation and do a conditional approval, and it was going to the town council.
Yes.
And they had the authority, and they could make any recommendation they wanted. Obviously, it had to be at some basis in logic.
Yes.
And there was a public hearing before the town council on that zone change.
And there was a reopened public hearing in the planning board before they made their final decision as well.
Just for clarification, and I don't really want to do this to you, but you mentioned the things that the planning board required when they alluded to denying the proposal, the application. Could you delineate what the 4 or 5 items were that they met?
Can you give me a moment
Yes.
to...
Well, I think it would be beneficial for the board.